only on Bloomberg Quint.
Hello and welcome to Bloomberg Quint. You're watching Insolvency Diaries. The Supreme Court's oral order yesterday in the power producers case led to different interpretations by lawyers. Unfortunately, the Apex Court's written order that was made available today doesn't clarify the situation either. Here's a quick background on the situation I'm referring to. Power companies had challenged the validity of the Reserve Bank of India's February 12th circular in various high courts. The circular directs banks to file insolvency and bankruptcy proceedings against all large loan accounts above 2,000 crore rupees if a resolution plan is not agreed upon within 180 days. Now, you would recall that the Allahabad High Court was hearing one such case and had declined to grant a stay on the circular. The RBI had then filed a transfer petition before the Supreme Court. Yesterday, the Supreme Court pronounced a status quo order, and today the written order states that all the petitions pending before the High Courts on this matter will stand transferred to the Apex Court. The order also states that the status quo shall be maintained in the meantime. So how should the Supreme Court order be interpreted, and until further hearing, can banks take no action against power producers? To answer that, I'm joined by senior advocate Sajan Poovayya, who is representing some of the power companies, and for an independent perspective, we have with us senior advocate Sidharth Luthra. Gentlemen, thank you for joining me on Insolvency Diaries. Mr. Poovayya, I would come to you first because you're representing several of the companies that are affected by the February 12th circular. How are you interpreting the Supreme Court's order?
I think the Supreme Court's order is very clear, and I wonder, I can't fathom why and where the confusion arises. But the Supreme Court order indicates very clearly that status quo as on today shall be maintained, which means status quo and or the date of the order, which is that if the banks have not proceeded against the power companies or any one of those companies who are parties to the litigation, the banks shall not proceed. If they have already proceeded against them, they shall hold their hands and not further precipitate those proceedings. The matter is coming up in a couple of weeks for the Supreme Court to hear, and therefore I think all that should be done in the interregnum is for the banks not to do anything other than what they have already undertaken. Therefore, the gist of the matter order is that no NCLT proceedings, winding up action, should be initiated under the RBI circular against, of course, the whole host of power companies and certain other companies as well outside the power sector. The textile sector has approached the court, the sugar sector has approached the court, the EPC sector has approached the court, and of course, the whole host of power companies have as well.
Okay. Mr. Luthra, can you weigh in on how you are interpreting the Supreme Court order? Are we to assume that, are we to go with the interpretation that Mr. Poovayya just laid out, or are we to read the status quo order to mean that the proceedings that are going on before, let's say, various high courts will, can't go any further, and those cases will now be, have to be heard by this Apex Court?
This is a case where certain petitions were sought to be transferred, and these are petitions pending in the high courts. The court has today transferred the petitions to itself. Insofar as the subject matter of the existing writ petitions that have been now or that have been transferred to the Supreme Court, to the extent of those cases, there is a stay. The stay does not apply beyond that. The stay of status quo essentially means, and I agree with my friend Sajan Poovayya, that the banks, if they've initiated proceedings, those proceedings will not be moved forward. If they've not initiated, they will hold their hands and the matter will be heard in November. However, if there are proceedings beyond the circular, if there are proceedings which are not subject matter of the writ petitions, if there are proceedings there are proceedings available to the banks which can be instituted outside the ambit of the circular, there's really no restriction on those proceedings, and that's how I would read the circular. And the reason for this order is very clear. The Supreme Court has called upon itself these matters. The idea is to balance issues and balance equities, and for the RBI to move the Supreme Court was a logical thing, because if the matter would have remained in the High Court, it would have taken some time, and then the matter would have travelled to the Supreme Court, and therefore the RBI, in order to ensure that there is uniformity of a decision, that there is clarity, and there is one decision on the applicability or otherwise of the circular, and that can be determined once and for all in the Supreme Court, moved the transfer, which has been allowed today.
Okay, all right. Mr. Poovayya, would you agree with Mr. Luthra that this order doesn't preclude banks or other creditors from initiating regular IBC proceedings, which don't necessarily fall under February 12th circular direction against the power producers and the shipping associations and the sugar associations?
Oh, absolutely. I wholeheartedly agree with my esteemed friend Mr. Luthra's interpretation, and that's correct. That's exactly correct. Please look at it. You should always look at an order from the perspective of what is in challenge and what has the court done. Now, what was in challenge in various courts, that is various high courts, the February 12th circular of the RBI, which mandated that all banks necessarily should go before the NCLT after the cutoff date, was under challenge. Now, what has the Supreme Court done? It has transferred the matters to itself and said that there shall be a status quo in the meanwhile, which means and only means that no action under the circular should be initiated. If no action has been initiated, don't do so. If action has been initiated, hold your hands. There is nothing preventing the banks or any other entity from initiating action under the Insolvency and Bankruptcy Code outside of the circular if such right exists. And these proceedings don't cover any one of those actions. So to that extent, I completely agree with what Mr. Luthra has said. There is no iota of doubt that if a bank or a financial institution or a creditor who is a corporate creditor has a cause of action under the IBC to initiate action before the NCLT outside of the February 12th circular, they are free to do.
And if a creditor chooses to initiate such an action, Mr. Poovayya, would it complicate things as they stand before the Supreme Court?
In fact, it's the other way around. Most banks are in support of the fact that this February 12th circular is really precipitating the issue and they should not be forced to go before the NCLT. Some of the largest creditors have gone on record in writing to indicate that the February 12th circular, which mandates action as of the August 27th deadline, is not correct. Therefore, I don't think there are any banks who are now indicating that they would like to nonetheless go before the NCLT under an IBC proceedings, irrespective of this circular. Now, of course, if there are a bunch of banks who are taking that path for reasons outside of the circular, they are free to do. There will be no precipitation on that count before the Supreme Court. At least the Honorable Supreme Court is extremely clear when this order was passed. I think the doubt has arisen outside of court, and I fathom why, or I can't fathom why this doubt has arisen.
Okay, Mr. Luthra, would this Supreme Court order, let's say, prompt some of the other companies that had not so far approached various high courts to try and seek relief from February 12 RBI circular as a result of this direction of the Supreme Court?
Absolutely. I think anybody who feels that the circular is under consideration, if there is a matter which is pending in a high court, then in view of there is a settled principle of law that if the Supreme Court is seized of a legal position, the high courts must stay their hands, and therefore it is most likely that people who feel that they are likely to be impacted by the circular would end up moving the Supreme Court, getting their petitions tagged along with the existing petition which is coming up in November, so that they can have the benefit of the status quo or of a similar status quo order as has been granted today, and the matters will be determined either which way, I assume in November.
Okay, Mr. Poovayya, would it be as easy, because you yourself have argued before the High Court and then the Supreme Court that the power producers are in a peculiar situation and they shouldn't be treated like everybody else when we are considering the directions in the February 12th circular. So a company that doesn't necessarily fall under this sector, would it be as easy for such a company to seek relief as a result of this direction?
See, I don't want to speculate how these matters will go because they are sub judice now. Of course, outside of the domain of court, if you ask me really as a matter of law or just legal debate and not really debating on the court proceedings, I must say that these are two different buckets. Then in one bucket are the power companies who indicate that the stress in the power assets are extraneous to the promoters. The promoters have not contributed, or the promoters are the only contributors to the stress, and therefore their stress must be looked at differently. Fortunately, the central government also has supported that view to bring on record before the Allahabad High Court an interministerial report other than the two parliamentary standing committee reports, where the central government, that is the executive, also agrees that the stress caused to the power sector are for reasons extraneous to the promoters, and therefore they must be given a breather, and the central government proposed a 180-day breather. So therefore the power companies are slightly in a better position to argue the matter vis-a-vis the RBI circular as compared to the other sectors. Now if you look at a sector such as textile, or a sector such as EPC contracting, or even a sector such as sugar, whilst there may be reasons for stress in those sectors, they don't have the support of the central government report or the support of a parliamentary committee report, which buttresses the fact that the stress is extraneous to the promoters. So I think the other sectors will slightly have a more appealing task to convince the court in terms of relief. But that said, I really don't want to speculate on a matter which is sub judice, and I think each sector will bring its own case to and its pleadings to bear before court on the next date of hearing.
Okay, Mr. Luthra, final question to you. How do you see this unfolding when the hearings resume in November, on November 14th? Because the validity of February 12th circular is in question, will the Supreme Court, and I'm asking you to preempt the direction of the court's thinking here. Do you believe that the February 12th circular's validity will be considered vis-a-vis the parties that are before the court, or it will be considered and maybe perhaps diluted to a certain extent for everybody else as well?
I think I've not seen the petitions, but I assume one of the issues that would have been possibly raised is the power of the RBI to issue such a circular. And the second part is the commercial aspects of it, the policy aspects of it. These are two areas of challenge, apart from the fact that in certain industries, as my friend Sajan has said, they've been treated differently, and the aspect of stress assets being peculiar to the power industry, all these aspects are going to be raised. It's an interesting area which is now being developed, whether the RBI can give such a direction, and if such a direction is given and a time limit set, what is the effect of that? Can it be across the board? Should it be diluted for different industries? So that categorization and that aspect has to be determined, and I think we're in for an interesting hearing in November, and knowing the way the matter, the speed with which the RBI has moved and the court has set it down, realizing the importance of the matter not only to just as an interpretive exercise of the circular, but the larger financial issues and the economic issues facing the economic stability of companies, as also the economy. It's an important matter which will have a far-reaching impact not only for this case, but in future policy making and future directions by the RBI and by the government as well.
All right, we'll promise that we'll closely track all those hearings right here on Bloomberg Quint. Mr. Poovayya, Mr. Luthra, thank you very much for helping us understand how the Supreme Court order should be interpreted. Thank you for joining us on Insolvency Diaries, and thank you so much for watching.